Another part of fundamental rights and fundamental duties in the series of constitution is in front of you. The Constitution of 1949 had a threefold provision for safeguarding the right of private property. It is not only guaranteed the right of private ownership, but also the right to enjoy and dispose of property free from restrictions other than reasonable restrictions. Firstly, it guaranteed to every citizen the right to acquire any property by a lawful means such as inheritance, personal earning, or otherwise, to hold it as his own and to dispose it freely, limited only by reasonable restrictions to serve the exigencies of public welfare, and b. by any other reasonable restrictions that may be imposed by the state to protect the interests of any scheduled tribes. Article 19(1)(f). The restrictions must, of course, be reasonable from the substantive as well as procedural standpoints. Thus, the restriction must not be an excess of the requirement of the interest of the general public for which the restriction is sought to be imposed. A restriction would be procedurally unreasonable if, in the absence of extraordinary circumstances, it is imposed without notice or without hearing or without assigning any reason. On the subjective satisfaction of an administrative authority. Secondly, the Constitution guaranteed that no person shall be deprived of his property save by the authority of law. Article 31(1). This implied that, short of the consent of the owner, a man's property can be taken only by the consent of the nation as embodied in the laws passed according to the Constitution. Any property which is seized by the police or the government without proper legal authority will be released at the intervention of the courts. As against its own subjects, a sovereign cannot exercise an act of state, and the private property of a subject cannot be taken away by the executive order, distinguished from an order made in exercise of power conferred by the statute. This clause was intended to be a protection against executive but not against legislative appropriation of property. The Supreme Court, however, held that the law which seeks to deprive a person of his property must be a valid law, which means a law enacted by the competent legislature and not inconsistent with any of the fundamental rights guaranteed by Part 3 of the Constitution. Thirdly, the Constitution enjoined that if the state wants to acquire the private property of an individual or to requisition, that is, to take over its possession for the temporary period, it could do so only on two conditions: that the acquisition or requisitioning is for a public purpose, that when such a law is passed, it must provide for payment of an amount to the owner, either by fixing the amount or by specifying the principle upon which it is to be determined and given. Article 31(2). The provisions of the Constitution as to the obligation to pay compensation for acquisition of property for public purposes, however, underwent serious changes as a result of amendments of the Constitution by the 1st, the 4th, the 17th, the 25th, and the 42nd Amendment Act. The net result of these amendments is as follows. A. Though the legislature was under the constitutional obligation to pay compensation, the adequacy of the compensation shall not be liable to be questioned in the court of law. In other words, when a law provided for the acquisition of person's property for a public purpose, he would not be entitled to challenge the validity of that law in a court of law on the ground that the legislature had not provided for payment of the full value of his property. This Fourth Amendment 1955 in Article 31(2) was necessitated by the fact that even the word compensation simpliciter was interpreted by the Supreme Court as implying full compensation, that is the market value of the property at the date of the acquisition. The government thought that it was not practicable to implement its program of national planning and development if the full market value was to be paid from the inadequate resources of the infant republic for every inch of the property which was to be nationalized. But even after the foregoing amendment, the Supreme Court continued to hold that the very word compensation implied full monetary equivalent of the property taken away from the owner, that is, its market value at the date of the acquisition. By the 25th Amendment of 1971, therefore, the word compensation in Clause 2 of Article 31 was substituted by the word amount, but again the majority of Supreme Court reserved an area for judicial intervention in the full bench case of Keswanand versus State of Kerala by holding that the amount which was fixed by the legislature could not be arbitrary or illusory, but must be determined by a principle which is relevant to the acquisition of property. The Indira government reacted by putting special laws in acquisition beyond the pale of Article 31 altogether by engrafting the exceptions in Article 31A to 31D, which will be mentioned presently. By a number of successive amendments, certain exceptions to Article 31(2) were introduced in Article 31A to 31D to exclude the obligation to pay any amount as compensation in the case of laws providing for acquisition by the state or nationalization if such laws relate to matters specified in these exceptional provisions. These exceptions to the obligations under Article 31 may now be examined in particular. Article 31A relates to a law for acquisition by the state of any state or other intermediate interest in land. The object of taking out the acquisition of intermediate interests in land from the obligations to pay compensation was to make it possible for the government to effect agrarian reform, which was so urgently needed to protect the interests of the tenants as well as to improve the agricultural wealth of the country. In order to facilitate agrarian reforms as well as social control of the means of production, it has been provided in Article 31A that not only a law providing for the acquisition by the state of any state or of any rights therein or the extinguishment or modification of any such rights, but also certain other laws which as a law providing for the taking over of the management of any property by the state for a limited period, either in the public interest or in order to secure the proper management of the property, shall be constitutionally violated even though it takes away or abridges any of the rights conferred by Article 14 and 19. While Article 31A accepts certain classes of laws, Article 31B, read with the 9th schedule, gives a blanket cover to particular enactments which are for the time being specified in the 9th schedule. Their number in 2000 is 284. They have been altogether immunized from attack on the ground of contravention of any of the fundamental rights. Article 31C, as inserted by the 25th 6th Amendment Act 1971 provided that any law which seeks to implement the directive in Article 39B or 39C, that is the plan of socialistic distribution of wealth and the means of production, shall not be void for inconsistency with Article 14 or 19. But the effectiveness of Article 31C was crippled by the decision of the majority of the Supreme Court in the case of Keshavanand that judicial review is one of the essential features of the Indian Constitution which cannot be taken away by process of amendment under Article 368, and that accordingly that part of Article 31C which stated that any legislative declaration that a particular law was made to implement the directives in Article 39 BC shall not be open to question in a court is itself unconstitutional. Undaunted by Keshavananda, Parliament enlarged the scope of 31C by the 42nd Amendment Act 1976 by including within its protection any law to implement any of the directive principles enumerated in Part 4 of the Constitution, not merely in Article 39B to C. As a result of this, if any law of acquisition was made with the object of giving effect to any of the directives, the reasonableness of such a law cannot be questioned under Article 14 or 19. Minerva Wills has, however, nullified this extension. The last fagot of exception, Article 31D, has been repealed by the 43rd Constitution Amendment Act 1977 and need not bother the reader. While the Congress government for over a quarter of a century had eaten into the vitals of Article 31(2) by successive amendments as outlined above, it was left to the Janata government to eliminate the right of property altogether from the list of fundamental rights in Part 3. This has been effected by the 44th Amendment Act 1978, which we have already discussed in connection with judicial review. Nevertheless, its incidents may be recapitulated in order to give a definite idea as to how much of the rights to property remain under the Indian Constitution after April 1979 and in what shape. Article 19(1)(f) has been repealed. Article 31(1) has been taken out of Part 3 and made a separate article, which 300A, which reads as follows: no person shall be deprived of his property save by authority of law. The result, in short, is that if an individual's property is taken away by a public official without legal authority or in excess of power conferred by law in this behalf, he can no longer have speedy remedy direct from the Supreme Court under Article 32, because the right under Article 300A is not a fundamental right. He shall have to find his remedy from the High Court under Article 226 or by an ordinary suit. Clause 2A(6) of Article 31 has been omitted. Clause 2 of Article 31 has been omitted, but its proviso has been transferred to Article 30 as Clause 1A to the article. Though Article 31 itself has been deleted, Article 31A, which was originally inserted as an exception to Article 31, has been retained with the omission of any reference to Article 31. Article 31A therefore remains to operate as an exception to Article 14 and 19 to shield the 5 classes of laws specified in Article 31A. Curiously, however, the second proviso to Article 31A(1) has been retained, giving the right to full compensation to the actual tiller. Even though Article 31 has been omitted and a reference to Article 31 has been omitted, Clause 1 to Article 31A, to which the second proviso operates as an exception. The above patchwork is bound to create confusion in the mind of a lay reader It would accordingly be profitable to outline the vestiges of the right to compensation which survive the onslaught of the 44th Amendment. These are twofold. Though the mass of citizens shall no longer have any guaranteed right to compensation if his property is acquired or requisitioned, and the legislature shall have no constitutional obligation to provide for payment of any solatium to the expropriated owner. Two exceptions of this general position are followed by 44th Amendment in two cases of acquisitions. If the property acquired belongs to an educational institution established and administered by a minority, the law of acquisition must provide it for such compensation as would not abrogate the right of the minority to establish and administer educational institution, which is guaranteed by Article 31 Sworn of Innuendo. This means that if the state chooses to acquire a minority educational institution, it must offer full market value or adequate compensation so that minority community may set up that institution at a suitable alternative site. If the state seeks to acquire the land which is personally cultivated by the owner and such land does not exceed the statutory ceiling, the state must pay to such owner full market value of his land as well as any building or structure standing thereon or appurtenant thereto. Though both the foregoing exceptions may be beneficial so far as they go, there is much to comment from the standpoint of constitutional law as from the national standpoint. As regards to the concession in favor of a minority educational institution, it is somewhat inexplicable why no such guarantee should be made in favor of the educational institution managed by members of a majority community. It is not education is pure and adorable whether it comes through the Ganges or the Jordan. In their overzealousness for the addition of a special guarantee in favor of the minority, which the fathers of the original constitution did not envisage, the fathers of the 44th Amendment took no time to ponder that by eliminating Article 31(2), they were taking away a right which had been guaranteed to all persons in India. Legally speaking, the new provisions in Article 31A is a tale which has lost its head by the repeal of Article 31(2). As to the right of a small tiller of land to full compensation for his land and building or other structures, one fails to understand why similar right should not be guaranteed to a poorer man who has not an inch of agricultural land but has a humble hut to lay his head at night. He may be a day laborer, a petty pensioner, or a landless peasant who tills another man's land. Are they less deserving? Would it be pertinent to point out in this context that even in the 1977 Constitution of the USSR, there was Article 13 which stated, the personal property of citizens of the USSR may include articles of everyday use, personal consumption and convenience, the implements and other objects of small holding or for building an individual dwelling. The personal property of citizens and the right to inherit it are protected by the state. In short, in USSR, every individual had the guaranteed right to hold and inherit a dwelling irrespective of his being an agriculturist, and the duty of the state to protect this right would obviously mean that the state cannot acquire or deprive the owner of his his dwelling house unless otherwise provided by the Constitution. The overzealous political leaders of India should know that the provision in 1982 Constitution of the Chinese Republic too is in the same strain. Though Article 6 provides for social ownership of the means of production, Article 13 at the same time guarantees to the individual to own personal property acquired by his personal income. The state protects the right of citizen to own lawfully earned income, savings, horses, and other lawful property. Article 39 further declares as a fundamental right that the citizens' home are inviolable. The net result of the foregoing provision seems to be that the state cannot take away an individual's dwelling house and similar personal property even by legislation, so that no question of compensation for compulsory acquisition may arise. In view of the drastic effects of the abolition of Article 19(1)(f) and 31(2), some jurists in India have put forth their belief that the Supreme Court would come to the rescue of the expropriated owners by holding that, notwithstanding the omission of such constitutionally guaranteed right to compensation, the court would derive such right from the legislative power contained in entry 42 of list 3, acquisition and requisitioning of property, read with the common law doctrine of eminent domain. Unfortunately, it has been possible for the author to persuade himself to this anachronistic assumption for reasons which have been elaborately given in the author's bigger work. In the circumstances, there is a case for restoration of some relief for the poorer sections of property owners as distinguished from capitalists or owners of the means of production, but such relief can be more easily brought about by further amendment of the Constitution than leaving it to the off chances of judicial amendment. Abstract declarations of fundamental rights in the Constitution are useless unless there is the means to make them effective. Constitutional experience in all countries shows that the reality of the existence of such rights is tested only in the courts. The power of the courts to enforce obedience to the fundamental rights again depends not only upon the impartiality and independence of the judiciary, but also upon the effectiveness of the instruments available to it to compel such obedience against the executive or any other authority. Under the Anglo-American system, such means have been found in the writs or judicial processes such as habeas corpus, mandamus, prohibition, certiorari, and quo warranto. The Indian Constitution lays down the following provisions for the enforcement of the fundamental rights guaranteed by the Constitution in the light of the above experience. The fundamental rights are guaranteed by the Constitution not only against the action of the executive but also against that of the legislature. Any act of the executive or of the legislature which takes away or abuses any of these rights shall be void, and the courts are empowered to declare it as void. Article 13. The Supreme Court strikes at the arbitrary action of the state. It has jurisdiction to enforce the fundamental rights against private bodies and individuals and award compensation for violation of the fundamental rights. It can exercise its jurisdiction suo motu or on the basis of bail. Apart from the power to treat a law as void for being in contravention of the provisions of the Constitution guaranteeing the fundamental rights, the judiciary has been armed with the power to issue the writs mentioned above, habeas corpus, etc., in order that it may enforce such rights against any authority in the state at the instance of an individual whose rights has been violated. The power to issue these writs for the enforcement of the fundamental rights is given by the Constitution to the Supreme Court and High Courts. Article 32 and 226. The rights so guaranteed shall be suspended except during a proclamation of emergency in the manner laid down by the Constitution, Article 359. Though a fundamental right may be enforced by other proceedings such as declaratory suit under the ordinary law or an application under Article 26 or by way of defense to legal proceeding brought against an individual, a proceeding under Article 32 is described by the Constitution as a constitutional remedy for the enforcement of the fundamental rights included in Part 3, and the right to bring such proceeding before the Supreme Court is itself a fundamental right in Part 3. Article 32 is the cornerstone of the entire edifice set up by the Constitution. Commenting on this article in the Constituent Assembly, Dr. Ambedkar said, "If I was asked to name any particular article in the Constitution as the most important, an article without which this Constitution would be a nullity, I would not refer to any other article except this one. It is the very soul of the Constitution and the very heart of it. The relevant provisions in Clause 1 and 2 of Article 32 should be noticed. The right to move the Supreme Court by appropriate proceeding for the enforcement of rights conferred by this part is guaranteed. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part." Article 32 thus provides a guaranteed remedy for the enforcement of those rights, and this remedial right is itself made a fundamental right, being included in Part 3. The Supreme Court is thus constituted the protector or guarantor of fundamental rights, and it cannot, consistently with the responsibility so laid on it, refuse to entertain applications seeking protection against infringement of such right on technical grounds. Thus, through a writ may ordinarily be refused on the ground that the petitioner has another adequate legal remedy open to him. Application under Article 32 cannot be refused merely on the ground where a fundamental right appears to have been infringed. The Supreme Court can make any order appropriate to the circumstances, unfettered by the technicalities of English prerogative writs. On the other hand, the sole objective of Article 32 is the enforcement of the fundamental rights guaranteed by the Constitution. Whatever other remedies may be open to the person aggrieved, he has no right to complain under Article 32. Where no fundamental right has been infringed, for the same reason, no question other than relating to a fundamental rights will be determined in a proceeding under Article 32. This is all about today's fundamental rights and fundamental duties in the series of Constitution of India. Thanks, regards, namaskar.